Season 2 of the official podcast sponsored by Texas Association of Specialty Courts. We have a very big announcement for you today. The podcast has been renamed to Justice and Recovery. Same show, but a new name. In Season 1, we had guest speakers from El Paso, Grayson, Harris, Hidalgo, Midland, Travis, Walker, and Williamson counties. We spoke to judges, probation representatives, a nonprofit leader, an alumni member from a specialty court program, and people who work frequently with state and national leaders in this field. We heard about adult, juvenile, and family drug court programs, adult and juvenile mental health court programs, veterans treatment courts, and drug court programs. We talked about best practices and more best practices. We also talked about success stories and what motivates the people in this career field. We had over 1,000 downloads for Season 1 alone. In Season 2 of the show, we're going to dive even deeper into these topics. We're going to speak with a licensed chemical dependency counselor, a prosecutor, a defense attorney, research specialist, and more. This show is just getting started. We have so much to explore with Texas Specialty Court programs. Today, we are going to start the season with something a little special. You will hear from Hillary Wright as she presents about Texas Specialty Court programs from an overview of their history to their basic operations. She will share about the types of programs recognized in Texas and some amazing success stories. Hillary is a prosecutor with the Tarrant County District Attorney's Office and joined the task board this past year. She is the current vice president and the Education and Outreach Committee chair. I will not be asking her questions, as this is an audio of the video you can find on our YouTube channel and our website, so sit back and listen to a very thorough overview. Don't forget, you can join our conversations by sending me questions to ask future guests or provide feedback on past episodes to justicerecoverypodcast@gmail.com. And as always, please help us by liking and subscribing to the show and sharing our show with people you know. Now let's get started.
My name is Hillary Wright, and I am the Vice President of the Texas Association of Specialty Courts. I have been a Texas prosecutor for 15 years, and I'm currently a Chief Felony Prosecutor in Tarrant County. As part of my job here, I am also a volunteer prosecutor for what is our DWI court. We call it the Felony Alcohol Intervention Program, or FAPE. I have been involved in specialty courts in Texas since 2015, and I'm so grateful for these programs and to be able to give back to our communities. And today I'm going to share with you information that I have that hopefully gets you involved and as excited as we are about specialty courts in Texas. Today we'll be talking about substance use disorders, objectives of specialty courts, the history and types of specialty courts. We'll talk to you about the team approach, best practices, the court process, eligibility, community benefits, and the legal and ethical considerations of specialty courts. Before we get started, there are a few important terms particular to specialty courts that we should cover. You will hear and see specialty courts referred to as many things, from drug courts, problem-solving courts, to treatment courts. Texas has selected to use the term specialty court to refer to these types of programs within our great state. The term team refers to the group of professionals who serve a unique capacity within each court. The court team as a unit works together with the judge at the helm to guide the participant to success and sobriety. Specialty courts are made up of phases, which typically begin with the high-intensity supervision and relax as the phases progress toward completion of the program as a whole. In specialty courts, we use the term participant to describe the people involved in the court process. So we don't call them offenders or defendants or criminals. They are people who need our assistance during a particular time in their life. National studies show that between 58 and 68% of U.S. adults incarcerated in jail or in prison meet the criteria for substance use disorders. 20.2 million American adults have a substance use disorder. That's about 1 in 10. And 43.6 million have a mental health problem. Nearly 8 million of these individuals suffer from co-occurring substance use and mental health use disorders. And unfortunately, people with these disorders are more likely to be incarcerated than treated. Specialty courts serve high-risk, high-needs individuals who have a substance abuse or behavioral health condition through a structured, non-adversarial approach that places an emphasis on treatment while providing accountability. The reason drug courts were created over 30 years ago was to address the overwhelming problem of repeat low-level offenders from cycling through the criminal justice system due mainly to their dependence on drugs and alcohol. They knew back then, and we know even better now, that the antiquated concept of throwing a person in prison did not change the behaviors when we're dealing with these offenders. Without treating the true issue, things were never going to change. The goals and objectives of specialty courts are simple. Improve the lives of participants by treating the root cause of the problem, addiction, and you will in turn serve the larger community goal of reducing recidivism. The goals and achievements of specialty courts are seen and supported by many. President Barack Obama talked about investing in alternatives like drug courts and spoke about saving taxpayers thousands of dollars per defendant each year. President George W. Bush also supported and wanted us to support drug courts. And Attorney General Eric Holder, when talking about specialty courts, talked about saving lives. Over the last 33 years, specialty courts have grown into a staple in the criminal justice system, with study after study showing that the process, when done correctly, saves lives and saves money. In 1989, the first drug court opened in Miami, Florida. At the height of the nation's cocaine epidemic, the war on drugs pioneers in Miami-Dade, Florida, came together to try something new, treat the addiction that was devastating so many. Headed by Judge Stanley Goldstein, the very first drug court brought out of the shadows both justice and treatment professionals who were equally frustrated with the system's handling of addiction and mental illness. For the first time, the justice system was treating substance use and mental health disorders as medical conditions rather than moral failings. Judge Stanley Goldstein happened to be a retired military police command sergeant major, a no-nonsense, hard-nosed, experienced law enforcement guy, a lawyer, and a judge, as McCaffrey put it. But when given the chance to work with these addicts who were at the low point of their lives, Goldstein would step down off the bench and give hugs for making the right choices just as quickly as he would throw them in jail for making the wrong ones. In 1990, spending on corrections exceeded $26 billion per year in the United States. The prison population at that time in the United States reached a record high of 771,243 people. The average cost in 1991 of state prisons for low-level drug offenses exceeded $1.2 billion nationwide. In 1992, the first drug court available for women opened up in Kalamazoo, Missouri. In 1994, there were a total of 44 drug courts in operation in the United States, and the inmate population in the United States reached 1 million. That same year in May, a group of intrepid drug court judges gathered for 2 days to create the National Association of Drug Court Professionals. NADCP would become the only national organization providing training, membership, and advocacy on behalf of drug courts and other treatment courts. In 1993, here comes Texas. Jefferson and Travis counties were the first drug courts opened in Texas. In 1995, NADCP held its first national conference in Las Vegas, Nevada, to provide training and education to drug courts across the country. Today, NADCP, which is now called All Rise, continues to hold an annual conference, hosting over 6,000 people for 4 days of an intense training. With the expanded growth in specialty courts, the U.S. Department of Justice began administering federal drug court grants to help fund expansion. That same year, the first DWI court opened in Donna Ana, New Mexico, along with the first juvenile drug court in Visalia, California. In Nevada, the first family treatment court opened its doors in Reno, Nevada. And not to be outdone, Idaho opened its first tribal healing court in Fort Hall. In 1997, with funding from the Bureau of Justice Assistance, NADCP published the Key Components, which provided a much-needed blueprint for the burgeoning treatment court field and immediately became the most important treatment court publication in existence. Decades later, research would confirm just how essential the 10 key components are to treatment court outcomes. Recognizing the need for ongoing training and technical assistance, NADCP created the National Drug Court Institute. With support from the Office of National Drug Control Policy, NDCI would become the premier provider of treatment court training and technical assistance in the United States. And in 1999, there were now 472 specialty courts of all varieties in existence across America. In 2001, the Texas legislature added specialty courts to the Texas Government Code. The language mandates that all counties with 500,000 persons or more have a specialty court. The 77th Texas legislature passed, and Governor Rick Perry signed House Bill 1287, which codified the U.S. Department of Justice's 10 key components of drug courts. The bill also required counties with populations over 500,000 to start drug courts by September 1st, 2002. Specialty courts must have a resolution passed by county commissioners and file with the governor's office. In 2003, the National Institute of Justice reports adult drug court recidivism rates are as low as 16.4% nationwide 1 year after graduation. In 2004, there were 1,621 treatment courts in operation, and NADCP held its 10th annual nationwide training. In 2007, NADCP launched the National Center for DWI Courts to help develop and grow the DWI court field. NCDC was launched at the U.S. Capitol with an event featuring race car drivers Michael Andretti and Robbie Gordon. In 2008, the first Veterans Treatment Court was established in Buffalo, New York by Judge Robert Russell. Jumping ahead to 2020, the National Drug Court Resource Center now boasts that 3,848 treatment courts are operational in the United States. Today, in 2024, there are over 4,000 specialty courts in operation in the United States. Over 200 of them are right here in Texas. Treatment courts can be found in 25 countries, including Canada, Europe, Central America, and Singapore. Throughout the decades, different types of specialty courts have developed to address unique needs of the community and participants served. There are over 14 types of recognized specialty courts nationwide, and 7 types specifically provided for in Texas law. Adult drug courts, veterans treatment courts, mental health courts, public safety employees treatment courts, commercially sexually exploited persons courts, juvenile courts, and family courts. Each variation of the specialty court concept was created to address a specific need within the community. Each uses the same approach of an interdisciplinary team of professionals to address participants' needs with the ultimate goal of steering them away from the criminal justice system. Adult drug courts are the baseline model for specialty courts and the one from which all others were spawned. Adult felony participants are high-risk, high-needs, usually struggling to meet basic needs due to their severe addiction and struggling to maintain any amount of sobriety. The target population for this type of court is repeat offenders and probation-eligible offenders. When we talk about DWI courts, they are a specialized version of the adult drug court, where an emphasis is placed on DWI offenders due to the added element of criminal thinking. DWI offenders are very different than the traditional drug court participant in that they normally are high functioning. They can maintain employment and achieve long periods of sobriety when required to. This can lead to a misconception that they are low risk or low needs despite repeated dangerous behavior. These courts can be for both misdemeanor and felony level offenses. Veterans Treatment Court is a model specifically for veterans or active duty military. They are suffering from PTSD and also mental health and substance abuse issues. The target population for these courts are veterans or active duty military who can have moderate risk and needs levels if the mental health diagnosis is met. They must either have PTSD, substance use disorder, traumatic brain injury, or a combination thereof. And they're required to have an honorable discharge so that they can qualify for Veterans Affairs services. Mental health courts are a court in which the focus is on stability of mental health disorders as they relate to substance abuse. With regard to these courts, the target population is those with serious mental health diagnoses, such as bipolar, depression, and/or schizophrenia. They also must have co-occurring disorders, which is mental health plus substance use disorder. While reentry courts are not officially recognized as their own subset of court, they are a popular version of the adult felony drug court operated in Texas. Reentry courts focus on the population of offenders who are returning from a long-term inpatient treatment facility, such as a judicial treatment center or SafeP. This type of court came about because the statistics were proving what we all knew to be true. It is easy to stay sober when you're locked up, but when you return to your community, your people, and your places and your triggers, that's a different story. Reentry courts help guide participants back into their communities while utilizing the tools that they learned during their time away. Commercially sexually exploited persons courts were created for participants who have been involved in prostitution and are facing charges for such. This type of court arose from the acknowledgement that individuals involved in these types of activities not only statistically suffer with substance use disorders, but also have an increased need for trauma and/or sexual abuse treatment. These types of courts pull victims of this specialized trauma away from other specialty court participants and provide a safe environment with this specialized treatment. The juvenile drug court focuses on the needs of juvenile offenders and their families. Juvenile courts have a unique obstacle in that they have this relatively small window of time to provide treatment services prior to that person aging out of the juvenile system. And they also struggle with getting families involved and committed to making their own changes. Another struggle that they have is that the overall challenge is there of brain development and lack of logical decision-making of these adolescents. And family drug courts are courts that focus on the reunification of families or the prevention of removal of the child from the home by CPS due to parental drug use. Most referrals for a family drug court come from the CPS system. Services are coordinated to help parents receive treatment for substance use disorders while gaining the needed parenting skills for the safety of the children involved. No matter the type of court, all specialty courts function with the same basic structure. The secret to success is the team approach to criminal justice. Working together changes the focus and the end result. A dedicated multidisciplinary team of professionals manages the day-to-day operations of the specialty court, including reviewing participant progress during pre-court staff meetings and status hearings, contributing observations and recommendations within the team members' respective areas of expertise, and delivering or overseeing the delivery of legal, treatment, and supervision services. Team members may vary from court to court depending on the needs and resources of the individual court program. Typically, a trial court judge leads the specialty court team. However, in some jurisdictions, a non-judicial officer such as a magistrate or a commissioner may preside over the court. Non-judicial officers usually report directly to a judge and require judicial authorization for actions that affect participants' liberty interests, such as jail sanctions or discharge from the program. Typically, a probation officer or pretrial services officer serves on the team. However, some specialty courts may rely on law enforcement or specially trained case managers or social service professionals to provide community supervision. The duties of the community supervision officer may include performing drug and alcohol testing, conducting home or employment visits, enforcing curfews and travel restrictions, and delivering cognitive behavioral interventions designed to improve participants' problem-solving skills and alter dysfunctional criminal thinking patterns. Often, an assistant public defender or private defense attorney specializing in drug court cases serves on the team. Among other duties, the defense attorney ensures participants' constitutional rights are protected and advocates for the participants' stated legal interests. Typically, an assistant district attorney serves on the team. Among other duties, the prosecutor advocates on behalf of public safety, victim interests, and holding participants accountable for meeting their obligations in the program. The prosecutor may also help resolve other pending legal cases that impact the participant's legal status or eligibility for the specialty court. Oftentimes, the prosecutor screens every application into the program to ensure the potential participant meets legal requirements for participation. An addiction counselor, social worker, psychologist, or clinical case manager may also serve on the team. In many specialty courts, participants can be referred to multiple treatment agencies or providers for substance use disorder treatment and other complementary services such as mental health counseling or vocational rehabilitation. Because it is unwieldy to have multiple providers attend pre-court staff meetings and status hearings, many treatment courts will designate 1 or 2 treatment professionals to serve as the treatment representatives on the specialty court team. A court administrator or clerk serves as the coordinator for the specialty court program. However, some specialty courts may employ a senior probation officer, case manager, or clinician as the coordinator. Among other duties, the coordinator is responsible for maintaining accurate, timely records and documentation for the program. They oversee fiscal and contractual obligations, facilitate communication between the team members and partner agencies, ensure policies and procedures are followed, oversee the collection and performance of outcome data, and schedule court sessions and staff meetings. Some other very vital team components vary from court to court. A peer support specialist may include other community representatives, peer mentors, vocational advisors, or sponsors from the self-help recovery community. Studies have not examined the impact of including such persons on the specialty court team. However, anecdotal reports suggest this practice can enhance team decision-making and effectiveness. Often, a police officer, deputy sheriff, highway patrol officer, or jail official serves on the team. Law enforcement is often the eyes and the ears of the drug court on the street. Observing participant behavior and interacting with participants in the community is the law enforcement job. They may also assist with home and employment visits and serve as a liaison between the specialty court and the police department, sheriff's office, jail, or correctional system. With regard to a data evaluator, including a data program evaluator helps ensure the specialty courts collect reliable performance data to report to grant-making authorities and is generally advisable for all specialty courts to ensure good quality program monitoring and evaluation. In some courts, specialized positions of case managers have been created to help effectively manage all aspects of a participant's case, including those outside the traditional probation pretrial role, like education, housing, food, childcare, healthcare, budgeting, etc. All courts have some form of drug testing protocol. An optional and very useful member of the team is a representative from the testing provider. As a dedicated member of the team, they can answer questions regarding testing methods, results, and options available. Evidence-based standards provide a blueprint to dramatically improve outcomes for specialty court participants. Adherence to these standards is essential for the purposes of credentialing, funding, and training new or existing specialty courts. A study of 69 drug courts revealed significantly better outcomes for programs that followed the 10 key components. The most effective and cost-effective drug courts worked collaboratively as a team, provided structure and accountability, offered wraparound services, trained team members, and monitored performance and outcomes. Investments in treatment and supervision services, staff training, program evaluation, and management information systems were recouped by greater improvements in outcome costs to the taxpayer. Since the first drug court was founded 30 plus years ago, the effectiveness of drug courts has undergone more research than virtually all other criminal justice programs combined. Published with funding from the Bureau of Justice Assistance, the key components provided a much-needed blueprint for the burgeoning treatment court field and immediately became the most important treatment court publication in existence. Decades later, research would confirm just how essential the 10 key components are to treatment court outcomes. Number 1, drug courts integrate alcohol and/or other drug treatment services with justice system case processing. Number 2, using a non-adversarial approach, prosecution and defense counsel promote public safety while protecting participants' due process rights. Number 3, eligible participants are identified early and promptly placed into the drug court program. Number 4, drug courts provide access to a continuum of alcohol, drug, and other related treatment and rehabilitation services. Number 5, abstinence is monitored by frequent alcohol and other drug testing. Number 6, a coordinated strategy governs drug court responses to participants' compliance. Number 7, ongoing judicial interaction with each drug court participant is essential. Number 8, monitoring and evaluation measure the achievement of program goals and gauge effectiveness. Number 9, continuing interdisciplinary education promotes effective drug court planning, implementation, and operations. And number 10, forging partnerships among drug courts, public agencies, and community-based organizations generates local support and enhances drug court program effectiveness. Now let's talk about the WHO. Section 123.002 of the Texas Government Code spells out who and who is not eligible for participation in a specialty court by providing that commissioners' courts or the governing body of a municipality may establish drug court programs targeting specific individuals. Generally, these are individuals whose crime either directly involves drugs and alcohol, or when drugs or alcohol significantly contributed to the commission of the crime. Generally, assaultive offenses are disqualifying. Each court will have its own particular way of handling how participants enter, progress, and leave the court program. The basic structure remains the same, utilizing the best practice standards for specialty courts. The general steps in the specialty court process look similar to those outlined here on the timeline and in the next slide. The first step in getting a participant in the program is a referral to the program. This can be as official as the prosecutor formally referring the case for court review, or as simple as the offender's grandmother recommending that they apply. However it happens, the important step of getting the information about the court to the potential participant is crucial. This is where prosecutors, defense attorneys, probation and pretrial officers, and other court-related staff play an important role. Following the referral to the program, most courts require the applicant to formally apply. Since specialty courts are voluntary programs, the potential participant needs to show initiative and demonstrate that he or she is willing to do their part to get the help that the court is offering. Applications can be as lengthy as a few pages and request all necessary data points, or as simple as a one-page "explain why you want this program" questionnaire. At some point in the beginning stages of the admission process, the potential participant is required or requested to observe a court session. By law, court sessions are open court hearings and available for anyone to attend. The purpose of the applicant observing the session relates back to the voluntary nature of the court. If they observe and they don't want any part of the system, then there's no reason to waste anybody's time. If the applicant observes and is interested and willing to engage in treatment and the court, they should move on to the next step. Screening takes place in two ways. The first is the prosecutor's determination of legal eligibility and willingness to extend a plea offer. In some courts, this eligibility determination occurs at the referral step. If the DA's office is unwilling to extend an offer of participation in the court, the applicant is normally out of luck. Some reasons why the DA may determine the applicant ineligible are concerns for public safety or legal ineligibility standards. If the prosecutor deems the applicant legally eligible, a screening for risks needs is required to ensure the applicant qualifies for the services. At this point in the screening process, some courts do a simple criminal risk and/or treatment needs screener, and others go ahead and perform the full assessment, including a TRAS, a SASE, or other assessment. Following the initial review process of the applicant, the state will extend an offer to the defendant, which includes the terms of completing a specialty court program. This could be a pretrial agreement with the hopes of dismissing or lowering a charge, or a post-adjudication deal to avoid prison, or a modification of probation situation to avoid a revocation. Whether the assessments were done pre-plea or saved for post-plea, a full clinical assessment is done, and it's needed in order to provide the participant the treatment he or she requires. Ensuring proper level of care for each participant is crucial to the treatment process to avoid under or over treating and ultimately causing harm. While the participant is involved in the multifaceted court program, the most crucial portion of their time is spent in the treatment process, working through the stages of changes and toward the ultimate goal of sobriety and individualized success. This process can range from SOP, supportive outpatient, IOP, intensive outpatient, inpatient services, recovery groups, etc. Following a successful discharge from treatment, a participant will enter the aftercare portion of the program. For some courts, this is their last phase before or immediately following graduation. Court programs typically have anywhere from 4 to 6 phases. Each phase will have a different and specific focus for the participant's time in the phase. The most tangible part of the court program process is the phase up or phase advancement of a participant. This is the best indicator for them that they are achieving their goals and making progress toward completion of the program. Each court has their own method for reviewing, granting, and processing a participant advancing to the next phase of the court. Some courts simply tell the participant when they are moving up, while others require them to fill out an application or request form explaining why they believe they're ready to advance. Advancing to the next phase is generally based on the accomplishment of certain goals, whether time-based, length or sobriety, achievement-based, number of meetings or court sessions attended, or treatment-based, cognitive goals and progress in stages. Advancing to the next phase is generally based on the accomplishment of certain goals, whether time-based, length or sobriety, achievement-based, number of meetings or court sessions attended, or treatment-based, cognitive goals or progression of the phases. No matter how the result of phase up is reached, celebration of the achievement during the court session is always part of it. Our certificate is an easy way to recognize the accomplishments of the participant and incentivize continued behavioral choices. With the progression through the phases comes changes to the requirements of the participant. They can include reduced supervision and increased freedom to make choices using their newly acquired skill set, or different and additional requirements like completing an educational assessment, getting a job, beginning to pay back fees, etc. The goals of the court in moving participants through the phases is to slowly release the institutional grip of the court/justice system and allow the person to navigate life on their own. The court team and participants put in the work and see the day-to-day benefits of their labor in the changes made, self-esteem gained, and the families reunited. The community as a whole also sees direct and indirect benefits of the specialty court process. Improve public safety by reducing recidivism, reduce costs associated with criminal case processing and rearrest, reduce overcrowding in jail, detention centers, and prisons, introduce participants to an ongoing process of recovery designed to achieve total abstinence from illicit and illegal drugs. It promotes self-sufficiency and empowers substance abusers to become productive and responsible members of the community, and reunifies families and protects children. The National Institute of Justice compared this to the traditional criminal justice system processing, treatment, and other investment costs and came up with that it averaged $1,392 lower per drug court participant. Cost saving is great for the community, but returning sober, law-abiding citizens to the community is priceless. In 2022, Dallas conducted a study through the Meadows Mental Health Policy Institute that reported a $9.73 saving for every dollar spent in the criminal justice system. Specialty courts have fun. They break traditional rules. They make trial courts jealous with their smiles and celebrations. But at the end of the day, they are still courts. The team has serious legal and ethical considerations that we must take into account with each staffing and order of the court. Specialty courts turn traditional notions and beliefs about the justice system upside down. Effective specialty courts educate potential participants about the differences between traditional court and the program they are considering. Often, a written contract or agreement is signed by the participant which outlines those differences, the policies and procedures of the court, and makes it clear why the participant is willingly and knowingly waiving any rights or privileges she might otherwise have. In a traditional court setting, the prosecutor and defense counsel each take an opposing position and pursue that position in an adversarial manner until the matter is concluded. In a specialty court setting, these two opponents must instead work in a collaborative fashion to promote the participants' successful completion of the program. This might be easier for the prosecutor, as prosecutors are not seeking convictions. Instead, prosecutors are seeking justice. Anyone can see how restoring someone to a productive citizen without incarceration could be seeking justice. While traditionally the prosecutor's role is one of championing public safety through incarceration, the prosecutor can also fulfill that role through diversion in appropriate circumstances. Arguably, the collaborative approach is trickier for defense lawyers. Most defense lawyers would be scared to death to allow a client to approach the bench and engage in a dialogue with the judge about any subject, let alone what violations the client may have engaged in during that period of time. There are no rules of evidence, procedure, or otherwise with respect to the in-court proceedings. In specialty courts, defense counsel performs the important role of educating the client about the risks and benefits of participation in the program. Defense counsel advocates for appropriate sanctions or awards for the client. Defense counsel should focus on what is best for the client, which in many cases is help with crippling substance abuse and/or mental health needs, which are most appropriately addressed in specialty courts. Normally, judges eschew public comments, media, etc. In specialty courts, judges become public advocates for the program. While judges need to be particularly careful about the appearances of impropriety, a judge is allowed, under applicable ethical rules, to participate in extrajudicial activities concerning the law, the legal system, and the administration of justice. Being a champion of specialty courts clearly falls within that realm. Substance abuse and/or mental health is an issue that is often talked about in specialty courts. We discuss individual clients' treatment regimes and progress in treatment with the team. Participants are provided with an informed consent release, which allows the substance abuse and/or mental health professional to divulge information related to the diagnosis, treatment, and progress to the rest of the team. And the team members agree not to divulge any information outside the drug court process. A lot of times we are called hug-a-thug. There are those who believe that specialty courts engage in coddling criminals. Uninformed persons may use pejorative terms to describe specialty court programs. While specialty courts hopefully do help criminal defendants, it's not a cakewalk. In fact, specialty courts require much more than any probation or parole officer can or does on their own. Participants are expected to appear regularly, usually weekly in the first phase of court, report more often to a supervision officer, attend recovery and/or mental health groups, perform community service, maintain employment, attend outside recovery groups such as AA or NA, get a sponsor, work the 12 steps, etc. Those of us not in a program would have difficulty complying with all that's expected of these participants. And if they do not comply, they're subject to a wide variety of sanctions, including incarceration. Now I want to talk to you a little bit about some real life stories, the reason why we do what we do. First is an example from an adult felony drug court. The participant was a heroin addict and a prostitute. She struggled initially in specialty court and was nearly discharged, but the team gave her one more treatment option, and something just clicked. She was able to graduate from specialty court, and then she graduated from college, and then she graduated from grad school, and now she has a PhD. There was a participant in a youthful offender drug court who was arrested for impersonating a police officer when he performed a traffic stop on an off-duty cop. He graduated from the court and got his case expunged, and now he serves on that Youthful Offender Advisory Board and works for the Dallas County Marshal's Office. And in a felony DWI court, there was a participant arrested again for a DWI. He had failed his last 2 DWI probations and been revoked each time. This time, he successfully completed the specialty court after 4 years, and he continues to work his program and live a sober life today. He now owns a business which grossed over $1 million in 2023. He got married in this last year and has a 6-month-old baby girl. Thank you so much for your time and your attention to this presentation. Please reach out to any and all of us so we can get you on your journey to becoming a part of a specialty court.
Thanks for listening to our show. As a reminder, see our show notes to contact us and find links to information discussed today. You can also find a link to learn more about our annual training conference that will be held on March 24th through 26th of 2025. I'll be dropping another episode soon, so stay tuned and be sure to like and subscribe to our show so you'll be notified when new episodes are available.